Hello, once again, welcome. Disability Law Show. John Scholes along with Sivan Tumarkin. You want to reach out during the show, got a lot to cover today. 1-855-821-5900, help@disabilityrights.ca. You can use that. We'll also go to mydisabilityquestions.com. That is a place where you can ask your questions, get Sivan or a member of his team to answer them. There's a database you can actually search and see if your question has already been asked. If not, leave it there and the team will get to it and answer you in depth for sure. A lot of stuff to get through today, Sivan, including 3 things your doctor can write to help you get approved for LTD. That is on the way. But first, the week that was. What's going on, pal?
John, again, very, very busy week with people contacting me and my team about their long-term disability claims. And, you know, one particular claimant, one call really stood out. And this one came just outside of Vancouver in British Columbia. This gentleman, who is 52 years old, was denied his LTD claim about 2 years ago. Now, this gentleman, you know, has a progressive neurological disorder. There's no question, based on everything his doctors have been saying, that he's unable to work in his job. He's got 2 teenage sons who actually are working part-time to help, you know, pay the mortgage. So it's a very difficult situation. And, you know, as soon as he was denied his long-term disability claim about 2 years ago, he actually contacted a lawyer, and that lawyer unfortunately told him to appeal that denial. And so he appealed once, appealed twice, and of course both times were rejected. And at some point he became frustrated. Apparently he paid this lawyer about $5,000 up front, you know, for doing these appeals, which were useless. And, you know, he ended up hiring a different lawyer. And so he hired that different lawyer, and different lawyer told him, okay, well, we're going to have to start a claim, which they ought to have done at the beginning. That's what the first lawyer should have done. And so they started the legal claim, John, and it's been just over a year and a half, and nothing is happening on the claim. And so this person, of course, who's watching the TV show here, who caught one of our shows, calls me up and says, you know, is this how it's supposed to be? In other words, I'm almost 2 years now post-denial, and there's nothing happening on my case. Every time I call my lawyer, I get the runaround, and I'm told, you know, he's talking with the insurance company, and they're trying to figure out what the next steps are, et cetera, et cetera. And I said, no, there's no magic to this. This is not brain surgery. It's really quite simple in terms of the procedure. We start a legal claim. The insurance company gets it. They get served with it. They appoint a defense lawyer, either somebody at a different firm or internally. They then provide a defense. Usually it's a standard defense. At that point, we pick up the phone to that insurance lawyer and we tell them, let's go to a mediation. Now, we can do something else in between them. There is a process called a discovery. But in many instances, you don't even have to go through that process. Insurance companies, once you start that legal process with them, they want, obviously, to get more documentation from your doctors, which is fine. That's what we do, John. We get these documents. We have a whole team. Everybody knows what they're doing. Our goal is to get the claim to resolution as fast as possible. And guess what? That's exactly the goal that the insurance company has too, once they're served with a claim. Insurance companies don't like to have these claims linger on and on. They don't like paying their lawyers, even if their lawyers are on staff. Once you start a legal process, insurance companies, you know, there's a secret that they don't want you to know, which is that they want to settle your case. Now, they may not pay what they ought to pay, in which case we got to push it forward. But, you know, most of the time, most LTD cases resolve at the mediation stage, because all the parties come together. There is usually a third-party neutral mediator, and we get it done. We get it done. Our clients get paid. Either they get paid, or as what happened, you know, with one of our associates out in Vancouver last week, you know, the company, the insurance company, reinstated the individual. They paid the individual what the person is owed and then put them back on claim. So, you know, we get these things done, and generally we get them done within weeks, months. Rarely do we have a case in our office, a long-term disability case, that spans over a year. And usually it's because there are some complications or some issues with the case. So, John, when this person called me up, told me he's got 2 lawyers already, and the case is about 2 years post first denial, his LTD claim, I was shaking my head, and I felt so bad for this person. And I told him, here's what you need to do with your lawyer. Here's what you need to get your lawyer to tell you right now. What's the next step? Is there a mediation scheduled? What else is happening? Have the medical documents been requested from your doctors? You gotta, you know, he's got to step on it. And unfortunately, many lawyers, what they do is they'll sign up an individual, and they won't do anything with the case. They'll shelve the case. And there are reasons of why they do that. I think most of the time the reason why they do that is because they have a lot of cases going on. They don't have proper support, proper staffing, and frankly, they don't care. They don't care that the individual and their family are struggling financially, that they may be out on the street, that they can't pay for their kids' education or expenses or whatever else, for food. And that's just wrong. It's absolutely wrong. So, if you're in that situation, feel free to give me a call, contact me. Won't cost you a cent to speak with myself or a member of my team. John, we're happy to give this information. We do this all the time, every week on this show, and that's what we did with this individual, and we're going to be able to help him if his current lawyer cannot.
Well, it seems like these lawyers that you're talking about, $5,000, big chunk of change up front, numerous appeals, year and a half. I have a feeling these are not disability lawyers. These are just all-purpose, jack-of-all-trade lawyers, possibly.
Yeah, that's what I find generally. When somebody tells you, I'll do your LTD claim, or I'll take your case on, personal injury case, any one of those cases, but you have to give me an upfront retainer, it's going to cost you X amount, unless there are really extenuating circumstances, like for example in a medical malpractice case where you may need to retain an expert before you start the claim to assess whether or not there was negligence. Unless it's one of those cases, no. Anybody who does this kind of work generally does this on contingency, which means that they get a percentage of whatever they recover for you at the end, only after the insurance company has been forced to pay you what you're owed. So if you have an LTD case and your lawyer says, pay me up front, to me that is a red flag unless there's something really strange going on with your case. It doesn't happen. And you mentioned jack of all trades. Gone are the days. Gone are the days when you can have one lawyer do family law and real estate and criminal law and immigration. No. It's like going to a doctor that can do every type of medicine. You don't find those kinds of doctors, right? You got your family doctor and then you got your specialists. And you have specialists because the medical field is so specialized. Same thing with law. You have employment lawyers like they have in our office. You have insurance lawyers. You have criminal lawyers. You want to go to somebody who has a certain expertise, and that's all they do. Because then they're going to know the nuances of the law, and that's how you're going to be able to maximize the amount of compensation owed to you.
Again, 1-855-821-5900, the number to reach out anytime. Email address we use is help@disabilityrights.ca. That's exactly where we're going now. Sivan, first one of the day. Email comes from Jared, says, guys, I'm an executive at a tech company with a private LTD policy through a major insurer. I started receiving LTD benefits in July of last year due to depression and anxiety. But my benefits were cut off early this year because they learned through Facebook that I had attended a few tech conferences. My 2 appeals were denied. Should the insurance company have cut me off when I wasn't attending the conferences as a work function?
Excellent questions, Jared. So first of all, I'm very sorry for what you're going through. And, a word to the wise here, this is something people need to understand. The insurance company will look at your social media posts. They will look at whatever channels you're using. They're going to snoop around. They're going to snoop around. Why? Because they can. And because they can get good stuff and then use that as leverage over you, either cut you off or pressure you to try to go back to work, whatever. And that's also in the context of personal injury. So, John, we've talked about this before. I usually tell people, be very careful. As long as you're telling the truth, as long as, you're not giving the insurance company extra red meat to chew on, as this gentleman unfortunately did here, where, they're using this against him, you should be fine. But you have a situation like this with Jared where he's done nothing wrong. Remember, he's dealing with mental health issues. He was approved initially in July of last year. Presumably he was approved because the insurance company believed what his doctors were saying about his disability, that he cannot work. And so for them to then say that because he went to a few conferences, and by the way, we have no idea what that means, went to a few conferences. Did he go there for part of the day? Did he have to leave part way? Did he take his medications that day, which enabled him to just sit? Sitting at a conference is very different than doing work, especially as an executive, but even as just, anybody else. And can you imagine, John, somebody who has full-on depression, anxiety, phobias, things like that, working at Starbucks 8 hours a day? Yeah. I can't see that. So no, the insurance company should not have cut him off. Absolutely not. I think they were completely wrong in doing so. But what bothers me here is, unfortunately, Jared fell into the trap that many people do, which is he appealed that denial. And of course, he did that twice, and twice he was declined. Remember, when you're appealing, not starting a legal claim, appealing a long-term disability denial or cutoff, you are essentially re-asking the exact same people who cut you off or denied you in the first place, the same company. There is no incentive for the insurance company to approve you. There just isn't. And so, you should think long and hard before appealing those decisions, because the reality is most of these appeals, this is anecdotal, but I can tell you it's the same experience that many, many lawyers that I speak with and adjusters, frankly, that I know personally, will tell you. These appeals are useless. It's a merry-go-round. At some point, you'll get off and you'll see that you're in the same spot. Actually, you're far back, because now you've wasted months and months and months. You have no money. You're strapped for cash. Your family's suffering. You're more anxious. Your situation is worse. And now you want us to help you, which of course we will, but we could have helped you the first time exactly when you were cut off. And for Jared here, John, I'll get in touch with him after the show. I'll explain his options. I think he has a fantastic case here, and I think we can actually force the insurance company to pay him what he's owed fairly quickly.
All right, let's take a short break. Sivan, when we come back from the break, 3 things your doctor can write to help you get approved for LTD. That is on the way. In the meantime, 1-855-821-5900. help@disabilityrights.ca is the email address. And if you want to find a pathway to our radio shows, simply disabilityrights.ca is the way to do that as well. Lots more Disability Law Show is on the way. Stand by.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back. Disability Law Show. To reach out, 1-855-821-5900, help@disabilityrights.ca. And you want to ask questions anytime when we're not doing the show, more of a private conversation, rather. MyDisabilityQuestions.com. Sivan is the way you do that. As promised, 3 things your doctor can write to help you get approved for LTD. Let's just roll right into the first one. That is, what functional limitations, if any, the claimant has.
This is very important, and it's important because, unlike a sick note to your employer where the doctor just writes the person is sick and needs a day off, the insurance company needs more. They need more meat on the bone, so to speak. And if you don't produce that, then, they could potentially deny your claim on the basis of insufficient medical documentation, insufficient support for your claim for disability. And so what I often tell doctors when I speak with them, what they should be writing is, look, you are the person's doctor, whether it's a family doctor or an orthopedic surgeon or a psychiatrist. You understand, obviously, from a medical standpoint, what is debilitating your client. Why is it that your client cannot work? To the extent that you can tie those medical issues, whether they're psychiatric or physical or a combination of those, you need to explain what are the functional limitations. So if you're dealing with somebody who was in an accident, for example, John, and the person is having trouble with their back, well, explain, not only the person has a herniated disc, but the person cannot stand or sit for longer than 10 minutes, as an example. If a person has a psychiatric issue, let's say major depressive disorder, you need to explain the person is unable to get out of bed, is unable to function because of X and Y. And I think that the more information the doctor provides on this issue in terms of the functional limitations, the more detail they're giving the insurance company, especially as it relates to the individual's type of work, I think the stronger the case is, the stronger the chance is that the insurance company will approve the claim. And if they don't approve, the stronger the chance that we can go after the insurance company and force them to pay. So functional limitations are absolutely key and crucial for a doctor's report that deals with long-term disability cases.
Second thing your doctor can write is the claimant's prognosis, the prognosis.
This is nuanced, and I'm talking now to the doctors out there, to psychologists, anybody that writes these kinds of letters. I typically, when I speak with doctors, I ask them, look, what is your prognosis? What do you think is going to happen in a week, 3 months, 6 months, a year? And you know, the longer out you are, the more difficult it is, obviously, for the doctor to provide an opinion. Sure. Nobody has a crystal ball. And what typically doctors feel comfortable doing is saying, look, if this is something that's ongoing and I think it's going to go on for the foreseeable future, I tell them, write down for the foreseeable future, if that's your opinion. Foreseeable future means that you're going to revisit this every so often, right? Every 3 months, 6 months, however often you see your patient, and you can update your opinion. I'm not asking a doctor to write, this person is disabled for life, unless it's a clear-cut case, you know, you have a brain injury or something. But I typically want to see some information about this. And when a doctor says, look, the person is disabled for, you know, the next month, and after that I think they'll be able to go to work, that's fine. The reality is, though, is that the insurance company, if they pay anything, it'll be for just 1 month. So, you know, I probe what the doctor's opinion is. I typically like to see doctors provide their opinion on this issue of prognosis, for how long do you think the person cannot work? But I never ever ask them to put down or even to give an opinion as to whether or not the person is permanently disabled. That's not the question. The question is whether or not they are disabled from doing their own occupation within the first 2 years of the policy, and are they disabled from doing any occupation after the 2 years, right? And so the question is, for me, for my clients, what is your prognosis? Is it for the foreseeable future that the person is unable to work? Or is it for the next month? Or is it forever? And usually doctors, when I explain this to them, they usually opt to say, you know, they say for the foreseeable future, because we're going to be reassessing the patient every so often. And, you know, the opinion may change, but for now, it's for the foreseeable future that the person cannot work. That is a good report. That is a report that can be very helpful for an LTD claim.
Okay, if someone's disabled, though, say looking at the employment scenario, the employer's not allowed to ask diagnosis. Can the insurer know the diagnosis along with prognosis?
Absolutely. 100% they can. What they cannot do, which they have done many times and still do, and it's illegal for them to do, is say that if you don't have a diagnosis, therefore they're not going to pay you. No, nowhere in the policy does it state that you need to have a diagnosis. And in fact, what is a diagnosis? A diagnosis is a label. So what they're saying is, unless there's a label for your illness, we're not going to pay you. No, you can't do that. When you look at the policy, virtually every LTD policy I have ever seen, the test for disability for the first 2 years is, can you do substantial portions or substantial parts of your own occupation? Beyond the 2-year mark, the test becomes, can you do the substantial portions of any occupation for which you're suited for by training, education, or experience? Nowhere does it say, do you have a diagnosis? And if you don't have one, you're ineligible to receive LTD. Despite that, John, doctors do, insurance do deny claims on that basis. So, you know, my point initially to answer your question is, yes, insurers can certainly ask what the diagnosis is, and I think it's great to give it to them if we have something definitive, but they cannot deny your claim. And if they deny your claim because you don't have a diagnosis, so you have a disability, but the doctors are not sure what the issue is exactly. They just agree that you have a disability. You should get LTD, and if you're not getting LTD, if you've been declined because you don't have a proper diagnosis or formal diagnosis, you should be contacting me immediately so we can help.
Okay, the third thing your doctor can write to help you get approved for LTD is this event, treatment recommendations. How about that?
This is important because every LTD policy, again, contains provisions that state that you have an obligation to mitigate. You have an obligation to, do the treatments that are prescribed for you to get better. And it's logical if you think about it, right? I mean, LTD is there as a safety net. That's the purpose of it. But it assumes that you're going to try and get better, which I think is a correct assumption. And frankly, people should want to try and get better, and most people do, in fact, try to get better. And so when your doctor is writing a letter for your disability claim, it is often very helpful for the doctor to write, here are the treatments that have been recommended by myself, by other doctors, whoever has recommended treatments. And then for the doctor to confirm that, in fact, the patient is doing those treatments, that the person is complying. And if there's non-compliance for any reason, to explain why. Right? Because insurance companies are going to look for these treatment recommendations, and then they're going to check, is the person actually doing those treatments? Is that person complying with those recommendations? And if the person is not complying, there better be a good and valid reason, and many times there is, but you need to be able to put that down. If the person is complying, fantastic. Again, the doctor should be putting that down. That's going to reinforce and strengthen the letter in support of the person's disability claim.
Coming up here, my insurance case adjuster is following me. What can I do about it? We'll tackle that, Sivan, after a short break. In the meantime, 1-855-821-5900 and disabilityrights.ca is the website. This is the Disability Law Show. More coming up.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Sivan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Disability Law Show. John Scholes here, along with Sivan Tumarkin. Always 1-855-821-5900, help at disabilityrights.ca, or mydisabilityquestions.com. That's another great place for you to reach out and ask your questions, which is exactly where we're going right now, Sivan. This one from Oliver. Oliver writes in, says, I've been off work for 3 years and suffered from chronic pain, migraines, anxiety, and depression. I have a new case manager who has ordered me to do a neurological assessment, which will apparently take 7 hours, not including travel time. Can I request that the appointment is broken up into 2 or 3 smaller blocks of time? Also, there is a limited time of how many assessments they request from any individual.
Excellent questions, Oliver. And you know, John, we do get these kinds of questions from time to time about these IMEs, these independent, quote-unquote, medical assessments. The answer is yes. You can definitely request that the assessment be broken down. And what I typically tell people when they're uncomfortable with the format of the assessment, or even, you know, if they have to drive for a long period of time, I mean, I've had clients that were told that they have to drive upwards of 10 hours to get to a certain assessor, which I thought was just ridiculous. I basically forced the insurance company to get them a taxi and an overnight hotel and pay for it. But, you know, the reality is, yes, you can request that. But what I would tell you, Oliver, is that, you know, get your doctors on board here to help you. Say to, you know, get your doctor to write a letter saying this is too strenuous for you, and that the doctor recommends that the assessment be broken down into parts. And so, you know, I always tell people, use your doctors as your shields. They are there to help you, to protect you. And, you know, in most instances, they'll be more than happy to help you. I think, John, that in a case like this, where a person's suffering from all these mental health issues, to have that person undergo an assessment for over 7 hours, which, by the way, I mean, it's not a walk in the park. They're not giving you cake and coffee there while you're doing this. It's very strenuous. I think there's nothing wrong with requesting accommodation and requesting that your doctor provide you with that backup. So 100%. Now, the question of how many assessments can they do, good question as well. That does vary from case to case, but I'll tell you this. I generally do not allow insurance companies to do more than one assessment per whatever the specialty is. So if we're dealing with a psychiatric issue, their psychiatrist can see my guy or girl once, right? Again, unless there is a good reason for that. If I'm dealing with an orthopedic issue, a bad back, a broken bone, something, no problem. My client will go to that assessment, but they will go there once, again, unless there is a very good reason for why the insurance doctor needs to see them more than once. And typically, there isn't a good reason. So typically, you are looking at one assessment per specialty, depending on what the issue is. If you have a multitude of issues, you may be asked to see multiple specialists in different specialties, right? So it really does depend. But again, Oliver and everybody else out there, you have questions about this kind of stuff, that's the kind of things, John, that I tell people, call me, email me, you'll get an answer within minutes. And if not from me, somebody on my team, and it's not going to cost you a cent to get this information.
Well, you mentioned the email, help at disabilityrights.ca. That's where we're going, pal. This time for Alice. Alice writes in, says, my mom worked as a law clerk for years, but had to stop working because of chronic pain, vertigo, and migraines. She tried to go to work last year but could not manage. She's getting treatment, but her insurer recently asked her to keep a daily journal of her activities, and she suspects she was followed grocery shopping and is worried her benefits are going to get cut off. Her doctors are supporting her, but is there anything she can do?
I think what she can do is exactly what she's doing now, which is to just basically do what the insurance company is asking by way of a journal. I don't see anything wrong with that. I think she needs to be truthful. I think that she needs to be specific and detailed. In terms of the journal, let me just actually step back for a second. There's a larger issue here, which is that when the insurance company asks you to do something, they can only ask you to do something that's in compliance with the terms of the policy. They can't ask you, for example, to do 1,000 jumping jacks if the insurance policy doesn't say you got to do 1,000 jumping jacks, right? So if the insurance company is saying keep a journal, one of the things I would tell this person is ask the adjuster where in the policy does it state that I have to keep a journal. And if it states that, or if it's something that could be interpreted as an obligation under the policy, then you have to do it. But sometimes insurance companies and adjusters ask people to do certain things that they really have no right to ask them to do. Now, in terms of surveillance, that's common. It's common with many insurers in the disability context and also in the personal injury context. Insurance companies are allowed to hire private investigators to follow you and to take video recordings of you, etc. They're not allowed to interact with you. Okay, the private investigators cannot speak with you. They cannot touch you. They cannot do anything like that. They cannot go into your home, but they can follow you into a store, into a restaurant. They can do all that. And I'll tell you, John, I've had cases when I was working for insurance companies where I didn't believe the claimant. I had my insurance client approve surveillance, which we had conducted on the individual, and the individual ended up looking like a complete liar. And I had a gut sense that he was a liar, but we were able to prove it. And so I tell people, look, don't worry about surveillance. I know it's not comfortable. I know that it seems like it's a breach of privacy, and to an extent it is. But insurance companies are entitled to hire private investigators, just like they're entitled to go online and Google your Facebook profile or LinkedIn or Instagram or whatever. As long as they don't make contact with you, these private investigators, and don't go into your home, they are allowed to do that. There are things you can do to protect yourself, and we can talk about that off air. I can do a whole show on that. But the reality is they can do so. Just tell the truth, and you're not going to get into trouble.
I can't imagine surveillance is cheap for these insurance companies. So what is the likelihood that regardless of whether you're being a good boy or girl, you probably are, if you're honest about it, they're going to find something, or at least try to find something out of it, yield something out of their the money they've paid?
Most surveillance is useless. I'll tell you that right now. I'm saying that also as somebody who used to order surveillance when I used to work for insurance many years ago. And it is very expensive. I mean, back then, I'm talking about, a decade and a half ago, I remember engaging a private investigator. And at that point, I can tell you it cost us $1,000 to $2,000 a day. Wow. So for people who think that they're being surveyed 365 days a year, that's not happening. Okay? No insurance company is insane enough to order surveillance for such a long time. What they typically do is they'll choose like a long weekend in the summer, or they'll choose 3 or 4 days during the week over a span of several weeks, and they'll give the private investigator or the investigating company a budget. They'll say you have $5,000, you have $10,000, whatever the situation is, go and do it. Do whatever searches you can do online, survey the individual, and that's what they do. No, they absolutely do not do surveillance for a very, very prolonged period of time. It's too expensive. And again, generally, this surveillance yields nothing. Okay, the case I told you about, John, where I'm the one who ordered it, and that was a long time ago, I can tell you that out of about 100 cases I ordered surveillance back then, maybe 1 or 2, like this one, yielded some results. Most of the times, it's a waste of money for the insurance company, but they're fishing. I can't blame them for fishing. It's their right to do so. All you got to do is tell the truth. All you got to do is make sure that you comply with the policy. Everything will be well. If you have any questions, you shoot them my way, and I'll help you.
All right, done for another show. Appreciate it, pal. Moving on, 1-855-821-5900 is the number. help@disabilityrights.ca. Email address. Shorten that down to disabilityrights.ca for the website. And, of course, mydisabilityquestions.com to ask any other questions. We'll see you next time. Disability Law Show. Thanks for hanging around.